We are fortunate today to have with us Jeffrey Kersten, Agency Liaison for the Wisconsin Bureau of Consumer Protection. In his role as Agency Liaison, Jeff travels around the state to educate the public, businesses, and law enforcement on privacy protection, data security, identity theft, and other areas of consumer protection. Jeff has over 12 years of experience as a police officer and as a prior consumer protection investigator for the Bureau of Consumer Protection. Thank you, Jeff, for agreeing to be part of our presentation today. And I'll now turn the screen over to you.
Excellent. Thank you so much for having me. So yes, my name is Jeff. I work for the state of Wisconsin in the Bureau of Consumer Protection. A rather long job title, as you heard Neil just try to introduce me. You should see my business cards. It's kind of crazy. Yeah, we try to get the word out all across the state on all those different areas of interest to consumer protection. Identity theft. We have presentations on home improvement contracts, motor vehicle repair contracts, business identity theft, data breaches. But then today we're here to talk about landlord-tenant law under Wisconsin law. We handle a lot of landlord-tenant complaints. We are the state's premier consumer protection agency. And interestingly enough, I think there's a lot of people throughout the state that kind of don't realize that we are here and that we exist, and we are here to try to help out with some of these types of issues. So today we can spread the word a little bit further. So let me just switch my screens around here real quick. There we go. Neil, can you just give me a heads up that you can see my presentation?
We can.
Okay, excellent. So we're just going to jump right in here to landlord-tenant rights and responsibilities under Wisconsin law. So first, I just want to do a little overview of what we do at the Bureau of Consumer Protection. At the federal level, if you've heard of the Federal Trade Commission, just kind of think of us as the state version of that. We ensure fair business practices for buyers and sellers. So we're impartial. So, and that really comes up with landlord-tenant complaints a lot, is that we don't take the side of the renter or we don't take the side of the landlord. We're an impartial mediation agency that that just comes at it from the middle and try to resolve these complaints. We are here to prohibit fraud and deception and unfair business practices in the marketplace. A lot of other areas that consumer protection gets into. And what gives us the authority to do that, of course, are state laws and administrative codes. And we're going to be talking about two of them very specifically. ATCP Chapter 134 and State Statute 704 are those two laws. So just a kind of a breakdown of the Bureau of Consumer Protection, we staff a consumer protection hotline. There's a 1-800 number, 1-800-422-7128. I think there's some documents that are being loaded into the chat right now. Our information is on the last page of all of these documents. That consumer protection hotline number is staffed Monday through Friday, 7:45 to 4:30. Great place to start out. If landlords have questions, if renters have questions, call us up. You get a live person on the phone. We can answer a lot of those questions. Now we're not lawyers, so we can't give legal advice, but we are able to answer a lot of those questions, and then we can always send out information. We have tons of what we call fact sheets at the state, documents that we produce that think of them as kind of information sheets, FAQs on lots of different topics, and we can usually find one that covers what the caller needs. Then there's the outreach and education team, myself and Francesca Johnson, another agency liaison with us at the state. Between the two of us, we cover the entire state doing presentations such as this. There's a mediation department. I physically sit closest to the mediation department at the office building. This is where all of our complaints start out. And certainly landlord-tenant complaints spend a lot of time in mediations. We're going to cover that a little bit more in depth coming up. Then there's the investigation department. That's where I used to be. The more egregious violations can be written up for investigation. And then we have enforcement authority as well. So depending on the type of case and the violations, whether it's violations of state law or administrative code that we have authority over, we can forward cases to local district attorney's offices. We can refer them to Department of Justice, U.S. Postal Inspectors, FBI. We have a lot of partners that we work with that, a lot of times we start out with the complaint, but then depending on where it needs to go, we'll get it to the right place. Top 5 consumer complaints of 2020. Telemarketing, number 1. Not really telemarketing, these scam phone calls, and I'm sure everybody is sick and tired of receiving. Reach out to me if you want to have an identity theft presentation. We can talk a little bit more about those types of phone calls and some strategies there. But landlord-tenant complaints, number 2 on the list. We handle a lot of landlord-tenant complaints. So here's those 2 laws that we're going to go into a little bit of detail. State Statute 704. It's about 12 and a half pages. We do not really over State Statute 704. This is the kind of it as the all-encompassing state statute that covers landlord-tenant law, rental agreements. This is what the courts use. So when 2 parties sue each other, or there's eviction proceedings that are going through small claims court at the county level, State Statute 704 is what they deal with. Derived from that through our rulemaking process is ATCP, which just stands for Agriculture, Trade, Consumer Protection Code 134. This is about 5.5 pages, so about half. Not quite as big as 704. This is what we have authority over, and there's some very specific things in here that we can actually deal with. Can't talk about landlord-tenant without talking about leases, written agreements. You don't always have to have a written agreement. There can just be a verbal agreement between 2 individuals that rent a room in somebody's house, and it's $500 a month, and it's just verbal. That can take place, but not as common. Usually there's a written lease. If the lease is in writing, a copy has to be provided to the tenant. And that's pretty important because the lease is really, really, that's where all the language is that we're going to need to dive into to determine whether there are violations of ATCP. If money is paid in the form of cash, whether the tenant asks for it or not, a receipt has to be given. Now, if the tenant pays their rent or security deposit, money order or some other way that there's already a trail, not necessarily a receipt's automatically required, but of course the tenant can still ask for it. We generally recommend that there be a written lease in place. Verbal agreements are just, when it comes to mediation and going through some kind of eviction proceeding at the courts, it's just it becomes one side says one thing, one side says another thing, and it's really, really hard to figure out what the facts are. 2 main types of leases with residential agreements: year-long leases and month-to-month. Depending on whether you are a landlord or a tenant and what you're looking for out of the rental agreement, there's advantages and disadvantages to both of these. So with a year-long lease, you're going to hear me say this a lot in the next half hour, 45 minutes, is that the only way a lease can be ended is with an eviction, unless it's mutually agreed upon. There's no other way that a landlord can have a tenant removed, but go through the eviction process, or of course, if you mutually agree upon it. With a year-long lease, the landlord cannot change the terms of that lease unless mutually agreed upon. So rent stays consistent. It's less volatile than maybe the month-to-month that we're going to talk about coming up next. Generally, at the end of a year-long lease, about 60 days notice has to be given to renew the lease. So you have plenty of time of kind of knowing what your situation is. Some year-long leases, when they end, they just kind of continue on into a month-to-month agreement, but not always. So you want to read your lease. It may be when the lease is up, the landlord's expecting the tenant to vacate the premises. Then there's the month-to-month agreements. Terms can be changed in as little as 28 days from either side. So today is what, October 22nd. So a landlord could give a tenant notice today that I want you out by the end of next month. Wouldn't have to be out by the end of October, because October 22nd to when rent is due on November 1st is not 28 days, but it would be 28 days notice before rent would be due on December 1st. So today notice would be given, tenant would have to vacate by the end of November. Otherwise, it'll be considered a holdover situation, which we'll get into coming up next. Also, the landlord would be able to raise rent. So could give notice today that rent is going up. Again, that rent would not go up on November 1st, but rent would go up on December 1st. And the tenant would either have the option of agreeing with that and choosing to pay the higher rent, or not agreeing to that, and then they would have to vacate. Some disclosures that have to be made. The landlord has to disclose who the authorized agents are. Obviously, the tenant needs to know who to pay rent to. Disclose code violations or any problems with habitating, moving into the apartment. We also work with the Wisconsin Department of Safety and Professional Services, who has commercial building inspectors that can get a little bit more into the code violations. And we have another segment coming up here in a few slides where we're going to talk about repairs, promises to repairs, and then utility charges. You definitely want to know who's responsible for utility charges. You don't want to have that surprise of, okay, you think rent is $1,000 a month as a tenant, and then there's another $250 bill on top of that for heating and water and electricity and all that. So have it disclosed whether utilities are part of the lease or the agreement, or they are a separate charge. And if they're a separate charge, how is that being determined? Are there separate electrical meters, water meters? Tenants have a right to seeing some of that to make sure that they're being charged properly. Earnest money deposits. So this is not security deposits. That's coming up next. Money paid down while a tenant is applying to rent an apartment. There's some very specific rules on collecting, returning, and withholding that money. Depends on whether the landlord denies the application, whether the tenant withdraws from the application before or after the landlord has made a decision, and there's some time frames in there. So not to go into too much detail on that, but if a tenant feels they should have got their earnest money back and they didn't, they can certainly file a complaint with us, and we can look into that. Security deposits. This is the one people are a little bit more, excuse me, familiar with. Generally, it's about 1 month's worth of rent, but there's, it's not limited to that. It can be higher. That a landlord holds on to, kind of protects the landlord if there's, you know, damages and things like that at the end. The landlord has some money to work with. When a tenant is checking in, highly recommended to do a walkthrough of the apartment. Note any existing damage. Tenants are able to receive a breakdown from the previous tenant of any money that was withheld from the previous tenant's security deposit, which is a really nice document to have, so that the landlord can't also withhold something you know, from that current tenant that they've already been compensated for. But the big thing with security deposits, we handle a lot of complaints with security deposits. A lot of people complain that they didn't get their security deposit back. It's that at the end of a tenancy, so when either the tenant moves out, the end of a lease, 28-day notice, and the agreement is dissolved, even if a tenant breaks the lease, once the landlord becomes aware that the tenant has gone, a 21-day clock starts, and landlord has 21 days to either return the security deposit or provide the tenant with an itemized list of any monies withheld from the security deposit. Again, if the tenant feels they should have got their security deposit back and they didn't, they're more than welcome to file a complaint with us, and we can look into it to see if a landlord followed ATCP 13406 correctly, and if not, we can reach out to the landlord and mediate that. Promises to repair. So there's kind of a couple different ways you can look at this. What we have authority over, and kind of the easiest way from our point of view to look at this, is that prior to a tenant moving in, promises to repair, that's what we have authority over. So the landlord says, your tenant is doing a walkthrough of an apartment, and there's say there's damage inside the apartment, or the hot water heater doesn't work, and the landlord says, oh, don't worry about that, well, I'm going to fix that before you move in. That type of promise has to be in writing, has to have completion dates, and the landlord has to meet those dates. That's a very, very cut and dried, if you will, and that's something that we have authority over. Where it becomes a little bit more tricky is that once the tenant has occupied the apartment, something breaks down. Of course, there's the mold issues and the bed bug issues, things like that. It becomes a little bit more tricky of who has authority over that. So whether that is us, whether that is the commercial building inspectors at the Wisconsin Department of Safety and Professional Services, or a local building inspector for the jurisdiction that that apartment is in. But again, just like I've said many times before already, tenants are welcome to file complaints with us. If it's something we have authority over, we will look into it. We'll mediate it. But if it's more appropriate to go to one of those other agencies, we can actually take that complaint and send it to those other agencies for the tenant. Some things that just cannot be in the lease. Some of this is, you don't really see it very often, but if some of this language is in the lease, it can actually make the entire year-long lease null and void. So there can be no increase in rent or decrease of services just because a tenant calls law enforcement. Unlawful eviction procedures. Again, the only way that a landlord can remove a tenant against their will would be to go through the eviction process at the small claims court for the county that the apartment is located in. Acceleration of rent, failing to mitigate damages. We're going to talk about mitigating damages coming up. Requiring payments of attorney's fees. Again, if any of this is in the lease, it can make the whole lease null and void. So if tenants feel that there's something in their lease that should not be there, like I said, more than welcome to file a complaint with us. So we'd be happy to take a look. Some prohibited practices. Obviously, landlords can't rent in condemned premises. Unauthorized entries. So this is one that people are pretty familiar with, where a landlord has to give 12 or 24 hours notice before coming into the apartment to do an inspection. Now there is a caveat to that if there's emergency repairs that need to take place, that time notification can be waived. And it really depends on how it's written in the lease, what type of notification the landlord has to give. We do take a lot of complaints about this. So if landlords are just coming in and they're not giving proper notice, we can certainly look into that. And that's something that we do have authority over. Automatic lease renewal. Wisconsin, it's getting cold outside. At least here in the Madison area, we had some frost this morning. A lot of these leases, you'll see these about not moving out in the winter. That can fall under this automatic lease renewal that we may have authority to look into something like that. Failure to deliver the premises. It's actually a violation for them not be able to deliver the apartment that they promised to the new tenant that they just entered into an agreement with. Remember this, because this is coming up on a slide here in the next slide or two, when we talk about breaking a lease and then that holdover situation I referred to earlier. Unauthorized late rental fees and penalties. It's pretty specific that if there are late fees applied, any new money paid has to go directly to the current rent. You can't have this situation where the tenant pays rent and the landlord applies it to the rental fees, and then of course now the tenant's behind on the next month's rent, and it becomes this ever evolving door of increasing rental fees. So there's some specific rules out there. Unlawful retaliatory self-help evictions. Landlord cannot turn off water, turn off electricity, change locks, do any of that type of constructive eviction. Again, have to go through the courts with an eviction case, the only way that a tenant can be removed against their will. And then misrepresentations. State statute 100.18 is the misrep statute, kind of a catch-all, if you will, if there's something that a landlord says that is some kind of a misrepresentation. Just that one law right there might give us the authority to look into that complaint. Terminating a tenancy. So all of this is state statute 704. Again, this is not something that we have authority over. This goes through the courts. If tenants are unhappy with how a court ruled, there's nothing we can do about that. We're not a higher authority. We can't tell a judge how they should be ruling in these cases, completely separate from our process. Generally, kind of how it works, let's look at the situation of a tenant didn't pay rent or behind on rent. So usually what the first step would be is a landlord can issue what's called a 5-day right to cure. Tenant has 5 days to pay the rent, to cure what was wrong. If the tenant doesn't pay the rent within 5 days, then the next step would be for the landlord to issue a 14-day eviction notice, and then they would have to go and file that at the small claims court for the county that the apartment is located in. Earlier this year, there were some CDC orders, some moratorium on evictions. That's all over with. But again, this all goes through the courts. We're not lawyers. We can't advise people. We can't give legal advice. But if a tenant does call, or even a landlord calls our consumer protection hotline, we do have resources available, legal help lines, legal aid lines that we can hand out phone numbers where, individuals can talk to attorneys for basically for free for 30 minutes or you get pointed in the right direction. But ultimately, if something is in the courts, we just recommend that they prepare as well as you can for that court case. There's nothing that we can do to kind of intervene there. All right, breaking a lease early and holdovers. So if a tenant vacates a premises before the end of a lease, so let's say you're in or a tenant's in a 6-month lease and just moves back home with mom and dad, it just stops paying rent and just moves out. That's breaking a lease. That lease is a legal contract. The landlord can continue to charge that individual rent through the end of the lease, but they have to mitigate, mitigate damages. Basically what that means is the landlord has to attempt to re-rent the apartment. If the apartment gets re-rented, landlord can no longer charge that person who broke the lease rent. You can't double dip as a landlord. But if that apartment stays vacant through the end of that lease, the landlord would be able to, in this case, charge 6 months of rent until that contract was over with. Then you have the opposite situation, not a tenant leaving early, but a tenant staying in the apartment later or after they were already supposed to be out. So let's look at like a month-to-month situation. Today, landlord gives 28-day notice that not going to renew at the end of next month. They don't have to give a reason for that. End of November comes, November 30th. Tenant would need to be out because that apartment might be promised to a new renter on December 1st. But what happens if the tenant just physically does not leave? It's called a holdover. The landlord can actually, without even having to go to court, charge that tenant double rent if they stay in the apartment after they're supposed to be out. Ultimately, the only person that can physically remove a tenant from an apartment would be a sheriff's deputy with an order from the court. And again, that's going through the eviction process. But the law is pretty specific on this about landlords recovering damages twice the rental, because you can see this horrible situation of now you've got new people that are ready to move into that apartment, and the apartment isn't vacant, and that's going to cause more and more and more problems. So our complaint handling process. Once we receive a complaint, we get that assigned to a mediator in just a matter of days. That mediator will review the entire complaint file, look for potential violations of state law or administrative code that we have authority over. Our process is that whether we see violations or not, we still will forward a copy of that complaint to the business, or in this case, the landlord, with a letter from us on state of Wisconsin letterhead that detail any potential violations that we see. Like I said, even if we don't see violations, we're still going to send that off. And then we give the landlord a 2-week window to get back to us with what they're going to do about the complaint. Now, obviously, if landlords respond right away, and depending on how the landlord responds, or if the landlord takes longer than 2 weeks, this process can, speed up or slow down. And then depending on how the landlord responds, that'll kind of dictate what the next step to the complaint process is. We do have, excuse me, we do have the ability to forward cases up to investigations and even to local district attorney's offices. I'll be honest with you, that doesn't happen very often with landlord-tenant complaints, but another housing issue, home improvement contracts that we have authority over, often that'll make those cases will make it down to investigations and get referred up to DA's offices. But it can happen with landlords. Prior to filing a complaint, we always recommend that the tenant and the landlord communicate with each other. Often these are just misunderstandings. Two parties, they didn't understand the language in the lease. One thought it said one thing, somebody else thought it said another. But sometimes communication breaks down, and that's what we're here for. When that communication does break down, tenants can file a complaint with us. Like I mentioned before, we'll be happy to take a look at that. Document. We want to see everything. So not only the lease, we always want to see a lease in a landlord-tenant complaint, but if there are emails or even text messaging that's gone back and forth between the landlord and the tenant, those texting can be screenshotted, and those photos can be uploaded as part of the complaint file. The more information that's documented that we can see, the better picture it gives us, allows us to make better decisions. Some of the publications that are going to be shared through the chat here. Landlord Tenant Guide is a pretty popular document that we produce, Tenants' Rights and Responsibilities. And then I also included both copies of laws, if you're interested in that. Some people like to read law, some people not so much. But again, 704 and ATCP 134, they should be loaded up into the chat. You can also find them on our website at datcp.wi.gov. And then lastly, I've just got a couple slides here about how to file a complaint with us. So easiest way to do that is just right through our website at datcp.wi.gov. Again, that just stands for Department of Agriculture, Trade, and Consumer Protection. Here's what our homepage looks like. Easiest way to find us, just click on this picture right here on the consumer side of the website. Our website kind of consumers, farmers, and businesses. Once you go to the consumer side, you're going to see a file a complaint process link right there. And then click on consumer protection. I know there's a lot of links, a lot of clicking. I didn't make the website, I'm sorry. But now that'll get you to this page right here where you're looking at filing a consumer complaint. You're going to see all the different types of consumer complaints you can file. Don't really worry about this too much. There is a specific one for landlord-tenant practices, but even right above that, if somebody was to click on the general consumer complaint online, click here, all of the complaints go to the the same place. So, you know, if we need to reclassify it on our end, that's not a big deal at all. And then that gets you to this page right here. Pretty simple. Tenant can fill out, you know, their information, as much information as they know about the business. And then there's a question of what the tenant is looking for. How would you like this complaint to be resolved? And then a narrative box where you can type up exactly what's going on. Kind of recommend that people type it up in a word processing program first, and then maybe copy and paste. Easier to edit things that way and make sure that it's nice and organized and chronological. This is the online way, but you know, not everybody's online. Not everybody has access to a computer. So simply just calling that 1-800 number, we can email out a complaint form. We can mail out a paper complaint form. However we can get that to a tenant, get it filled out, get it back to us. We'll get that into our system, and we can start working on that and start mediating that complaint. Here's my information. Again, there's that 1-800 number. There's an email address specifically for our hotline, kind of the same people that answer that 1-800 number, and our website. Always looking at scheduling more presentations. So if you want to have me come out and either do, you know, this presentation, a home improvement contracts presentation, or our identity theft presentation for the individuals that you work with, you know, just shoot me an email. I'll be happy to work with you and try to set something up. The entire state, we can do live presentations, or like this, we can do a virtual presentation. And with that, Neil, I'll kind of toss it back over to you. I see it looks like a couple questions have popped in. Let me pull up my excuse me, my chat bubble and see if I can catch up on what's going on with the questions.
Well, thank you, Jeff. That was a great presentation. The one question that has come up is, if a tenant moves out during the middle of a one-year lease, does the 21-day required notice to return the security deposit start when the tenant moves out, or when the landlord becomes aware of the tenant's departure, or when the keys are returned to the landlord?
I'm sorry, go ahead.
Can the security deposit be applied to the rent currently due, as well as future rent due to the terms of the lease? For example, if the tenant leaves on the 5th of the month and the next month's rent is not due until the 1st of the month, that rent would not be due within the 21 days. And assuming that the landlord attempted to mitigate the damages by advertising to re-rent the apartment, can the security deposit be used for continued future rent due? Good question.
Yeah, lots going on there. So
yes.
So in that situation, yeah, it could easily be that the landlord doesn't even know that the tenant has broken the lease and moved out early. So yes, the landlord has to become aware that the tenant is gone. Once the landlord becomes aware of that, that's when the 21-day clock starts. And one of the things that a landlord can withhold money for would be rent. So, and generally, you know, security deposits are about 1 month's rent. So, you know, like my example, you know, breaking a lease early at the 6-month mark, the tenant's probably, I guess, not getting the security deposit in that situation unless the landlord is immediately able to re-rent that apartment, and then there's nothing else to withhold the money. But assuming that, you know, they're not able to mitigate the damages that fast and get the apartment re-rented, probably that security deposit is just going to be withheld for the next month's rent. And then there's still, you know, 5 more months worth of rent that the landlord is going to be trying to collect until they're able to re-rent the apartment. So yeah, I mean, I think the main part of that question is, can security deposit be used for future rent due? And the answer is yes to that. That is one of the things that is allowed. Subsidized housing, different rules and laws. So if we're talking about like Section 8, HUD, things like that, a lot of those are federal programs. So that is often there are some different rules with that, but we can always try to mediate complaints as well. And our mediators are pretty well versed in that. So, you know, we handle what we have authority over. And if there's something that needs to be handled by HUD or another government agency, we can send the complaints to those agencies as well. Automatic lease renewals allowed if proper notice is given. Stated that rent will increase to a stated amount. So, yeah, automatic lease renewals do get tricky. If proper notice is given, I'm not sure. The rent will increase. Generally, as long as proper notice is given, that's what we are, we deal a lot with that, and then the tenant has the option, if they want to pay the higher rent, they can agree to it. And if they don't, they can, end that agreement. But automatic lease renewals are tricky. I'll be honest with you. I don't probably know that part of the administrative code off the top of my head perfectly, but I could research that a little bit more for you. All right, I'm just going to keep going down the list, Neil. Let's see, another question coming in. Someone sends an email. Turnaround time. Oh yeah, we're really, really good at contacting people. So if you send an email to what's up on the screen right now, that DATCP hotline at wisconsin.gov, you'll probably get you should get a response today. And of course, you just call the 1-800 number, you get a live person. So we're really good at staying up on that.
Let me interrupt here. And how does the agency deal with the various languages that we have here in Wisconsin? And are many of the consumer complaints due to just a language barrier?
I mean, certainly that can play a part. We do have a dedicated Spanish-speaking mediator that handles all of our Spanish complaints. So between English and Spanish, that probably handles the vast majority of them. But if we do run into another language, there are interpreting services out there that the state has contracts with, and we're not going to let a language barrier hold us back from looking into a consumer issue. So it might just need a little bit of time to set up the proper services to handle that complaint, but we're more than willing to do that.
Another question that came in through the chat is, can a lease be broken by a landlord filing bankruptcy?
Filing bankruptcy. So generally, so we see a lot of situations where the landlord will sell while they're in the middle of a lease, and a new buyer, when they come in, they have to assume the terms of the lease for the tenant that's already living there. Bankruptcy, that obviously has to go through the court. So probably depend on how a judge rules on that. But I would think if there's property, eventually there's going to be another buyer for that property. And I would think those same rules apply, but that's a really, really good question. I'll be honest, I have not ran into that one. Not the bankruptcy situation, but we see it a lot where landlords will sell. Pretty good rule is that as a tenant, as long as you have that signed lease, you're good for the terms of that lease, even if ownership changes hands.
Fair enough. With regard to the security deposit, is it all or nothing, or can it be prorated based on the work that has to be done? And then who determines the value of that work? I can say that, I could go down and fix that faucet at Home Depot for $25. Why are you charging me $250?
Exactly. Yep. So no, it's not all or nothing. So at the end of, or within that 21-day window, an itemized list has to be provided to the tenant one way or the other. So either the tenant, yes, the tenant could get all their money back. They could get none of their money back. They could, some of their money back. And it'll all be determined by what the landlord itemizes. But the landlord's required to write that down. So if there's something that is in there that's been misrepresented, that, it only cost the landlord $20 to fix this faucet, or $25, like you said, and they put on the itemized list $250, the tenant now has documentation, and landlords are going to get themselves in trouble if they're misrepresenting things on those itemized lists. That easily could be something that could make it into court, or something that a document that we can use during our mediation process.
Mm-hmm. And then how about the renovation of a building? I assume that a landlord would have to give tenants adequate notice that we're going to be renovating and it may impact your space or whatever. Even replacing the carpets in the hallway can be disruptive.
Yep, exactly. Renovations, often it kind of that's where that, the proper notice has to be given before landlords can come in order to make repairs, with the exception of the emergency repairs. But yes, that can be a very disruptive thing if in a tenant's living space, the landlord gives proper notice, but then all of a sudden, here's construction people coming in and they're changing carpet, or they're doing whatever. Urge communication, but if it's something that the tenant feels is just not right, welcome to file a complaint with us. I'll be honest, I'm not sure what authority we would have to be able to stop something like that, but we can certainly mediate it and try to come to an agreeable resolution from both sides.
The triad of Wisconsin deals with a lot of experiences of older citizens in the state. If a person who is able-bodied rents a space and then for some reason becomes disabled, is there a requirement that adequate accommodations be made?
I would think so, but I don't think that's something that we have authority over. That would be, I know the Department of Workforce Development handles housing discrimination, and then of course there's the Americans with Disabilities Act. I mean, there's some other agencies out there that probably deal a little bit more with the accommodations, but that can be hard to figure out, right? I mean, who's the tenant supposed to go to if they're not sure where to go with this one particular complaint? And that's something we really kind of pride ourselves on at the Bureau of Consumer Protection, is that it's easy for individuals to file complaints with us, and our process, of course, we review it, we look for something that we have authority over. If we have authority over, we'll take it. But if we don't have authority over it, we're really, really good at finding which state or federal agency that complaint needs to go to, and we can actually forward it there on the tenant's behalf. So it's not like we're just going to send it back to the consumer or the tenant here and, sorry, there's nothing we can do about it. We'll try to get it to where it needs to go. But yeah, I don't think those types of accommodations, I know there's nothing in 134 I'm aware of that covers that, but I'm sure it's covered somewhere else.
And to emphasize your point, you'd be the first ones to go to say, what can I do?
Yeah, I think we're a really good first stopping point. And like I said, we'll take
Excellent.
it if it's ours. And if not, we'll really work with you to get it to where it needs to go and help you navigate that.
Excellent. Thank you. Are there any more questions that would like to be raised while we've got Jeffrey on the line? I can mute. I'll mute. Let's see. Oh, there are some more. Let me scroll.
There's a couple more coming in.
Okay, yes. Here, I'm sorry, I should have scrolled down. If someone sends you an email in the general department email, what is the turnaround time and what will it take them to expect someone to contact them? I think you said within the day, did you not?
Yeah, we're really good at contacting people, so that's a really fast turnaround time on that. Let's see here. Who should be contacted if the landlord has been notified by a tenant that the heat is not working? So, I mean, if the landlord's just refusing to fix that and the heat's not working, and now we're getting into a colder weather outside, things like that. We certainly understand those issues. We urge people to file complaints with us sooner rather than later, because I'll be honest, our processes are not fast. Like I mentioned earlier, we give this 2-week window to a landlord to get back to us with what the response is. Depending on how much time the landlord actually takes, can kind of, it can take a while for us to get to the bottom of things. So starting out, get the ball rolling with us faster is going to help out in those situations. If a person moves into breaks a lease because they move into an assisted living facility, that I'm not sure if that is a reason to break a lease or not. I'll be honest, I'm not sure about that one. I could get back to you, Neil, with an answer to that one, and you could forward it on to the. Probably want to research that a little bit more. I certainly don't know all this off the top of my head. There's a lot of law when it comes to landlord tenant.
Well, that kind of goes to the question that I raised from the standpoint of if somebody becomes disabled and needs special assistance, and it's a long-term issue, are they on the hook for the lease? It's a valid point, and we'd appreciate you getting back to us on it.
Yeah, I will on that one as well. And then the last question here. So last month rent plus. So I think if I understand the question correctly, landlord is renting to a younger person or maybe somebody who doesn't have a rental history. So they're asking for lots of money up front. First and last month rent plus double security, so double what the rent normally is. There's nothing in 134 that I'm aware of that limits how much security deposit a landlord is able to ask for, or asking for rent up front or the last month's rent. As long as that's disclosed ahead of time, then the renter has the option of accepting those terms or not. So if they're, we just don't want to see a situation where it's like the lease is already signed and then the tenant finds out they have all these extra things that they have to pay that they didn't know about. That's when no disclosure is made, there's more of an issue. And then the difference between us and the Tenant Resource Center. So we're a state regulatory agency. We have authority over that ATCP 134. We work a lot with the Tenant Resource Center. They offer a lot more legal advice than we do, where we are more of a complaint handling agency that's mediating those complaints. But there are definitely some similarities.
Another question has been raised in the chat box. Do the county health departments get involved with you in bad housing situations? And we'll use the example of the heat not coming on a 0-degree day. That almost becomes a code violation versus, and a very difficult living situation. How do you work with the county or the city in that respect?
Yep. So there's so one of those disclosures that a landlord has to make about habitability at the beginning of entering into an agreement is that if any room in the apartment is not able to maintain, I think it's 67 degrees. It's really, really specific on like how it has to be measured, like from directly in the center of the room. That has to be disclosed. But now you run into the situation where the heater breaks, and so yeah, we do work with other agencies. I mean, off the top of my head, I don't know how many times county health departments have forwarded complaints to us. We handle lots of these complaints and take lots of these phone calls every day. But between us and the local building inspectors and the commercial building inspectors, like you mentioned, Neil, a lot of that's going to fall into code violations. The commercial building inspectors at DSPS can get involved.
Excellent. Are there any other questions? Well, Jeffrey, this has been great. It addressed exactly our intent when we set up housing as our fourth topic for our 2021 virtual Triad conference, and we very much appreciate your expertise. It would be great if you could research the one question and get back to us, and we'll get it to the person that asked the question with regard to if you moved into a long-term care facility, is your lease still valid?
Yep.
Or is it a valid reason? Yep.
Yep. Sorry, I'm going to write that down. Long-term care facility, and then also the accommodations for a disability.
Excellent. Oh, we have time for one more question.
Sure.
Chat. Okay. Oops. Oh, what is the difference between the Tenant Resource Center? And he answered that.
Yeah, I see another one in the chat about filing an appeal about the security deposit. So
I beg your pardon.
So yes, that would be right through our agency. Security deposits are definitely something that we have authority over. Once the 21-day clock has elapsed. So, a lot of times we'll get this complaint, within the first week of a tenant, vacating an apartment, they want their money back right away. There's no violation there until if the landlord or only if the landlord takes longer than 21 days. So might not be something we can look into right away, but once that 21-day clock has elapsed, the tenant hasn't received notice. Tenants can also help themselves out by simply providing their forwarding address to the landlord to get their security deposit back. And be surprised how often that does not take place. And the way the law reads is that the landlord has to send the security deposit back to the last known address. Well, if the last known address is the apartment and there's no forwarding, it's not going to make it into the tenant's hands. But yet the landlord actually met the requirements of the law because they sent it to the last known address. So tenants, there's some things tenants can do to help themselves out in those situations as well. But yeah, anything security deposit related goes right through us, so we can handle that.
That's a very valid point to, if you do move out, make sure that there's a forwarding address and the check can get into your hands in an appropriate amount of time. And I've found with forwarding some mails, it gets delayed considerably. So it's important to make sure that they have the right address.
Yeah, and if a tenant receives it later on and then realizes they no longer have a complaint, they can drop that with our agency. That's not a problem. And then I know we're right here at the top of the hour. I think, Neil, you're probably going to take a quick break before your next speaker's on. So I just want to give one more plug for our agency and our outreach programming. I know we got a lot of people on this call, so I'd be missing my opportunity if I didn't say this. But please reach out to me if you're looking for this type of presentation, directly to the consumers that you work with. Like I mentioned earlier, we also have a home improvement contracts presentation and a solid hour presentation on identity theft. That's really, really popular right now. Be happy. And if you're looking for something that we don't currently have a presentation on, and it's in the realm of consumer protection, we'll create one and be happy to come out and talk to you.
Appreciate it. Thank you very much.